So welcome to the webinar. Today we are at Legal Aid New South Wales Central Sydney office, and before we start we would like to acknowledge and pay our respects to the Gadigal people of the Eora Nation, who are the traditional owners and custodians of the land we are broadcasting from. In the webinar today we're discussing something that community workers and the public often say, yeah, that would be great to know more about. We're going to be explaining grants of legal aid in New South Wales. To be clear, I guess the main message for community workers is to let them know that it is best to get legal advice first before applying for legal aid, and to get a lawyer to help them with the application form, but that's not always possible. So this webinar will hopefully give you a better understanding about grants, to have some initial conversations and to give some information to anyone you support who may need a lawyer. Today it's legal information and not legal advice, but we will let you know where people can go to get legal advice. So my name is Natalie. I'm from the Community Legal Education branch here at Legal Aid, and with me today I have three colleagues from Legal Aid New South Wales to deliver our Grants 101 session. We have Aideen and Anna from the Client Eligibility Unit, and you'll recognise Aideen by her lovely accent. And we also have Bridget, who's a family lawyer from the Grants team. So Bridget, Aideen and Anna, welcome.
Hi, thank you. Hi everyone.
And before we start, we're going to do a really quick poll, and I guess this is also a practice for you, and to get an understanding for us about where you're at with your knowledge of grants. So you can see on the screen in front of you, how would you rate your current understanding about grants of legal aid? I don't know anything about grants. I've heard of them, but don't really understand how it works. I have helped people with grant applications and have some idea, or I have a fairly good knowledge. So thanks everyone for answering that. I'll just close that poll and share the results. So Aideen, Anna and Bridget, we've got about, let me just stop that. So most people say that they don't know it. So most people have heard of grants but don't really know how it works, and there's a lot of people who don't know anything. So I guess it is called Grants 101, which means beginners or introductory, so that is really good to know, and we are all in the right place. So thanks for that, everyone, and let's get started. I'm going to tell you just a little bit about what we'll be talking about today. So you can see on your screen in front of you a brief overview. We'll do a bit of an intro about legal aid and grants, what is a grant, just to begin with. Then we'll get into the eligibility test. So what makes someone eligible for legal aid? And that's going to be the main part of the webinar. We'll also talk a bit about applying and also reviews and appeals, and of course how community workers can best assist. So on that note, I will hand over to Anna to talk about legal aid and grants.
So Legal Aid New South Wales, we are the largest legal aid agency in Australia. We provide a range of legal services to socially and economically disadvantaged people. We are an independent statutory body that reports to the New South Wales Attorney General, and we are just one part of a much larger system of justice. Our other main partners are community legal centres, Aboriginal Legal Service and Law Access New South Wales. So Legal Aid New South Wales, we have 24 offices across the state. We have 221 regular outreach locations, and our in-house practice is split into three main areas: criminal law, family law and civil law. The grants division of Legal Aid is responsible for administering grants of legal aid, and so that's what we're focusing on today. So in terms of what is a grant of legal aid, on the screen you'll see images of where a good place is to start to get some information. There's a section on applying for legal aid under the Get Help tab on the Legal Aid website. And we also have some simple animated videos called Can I Get Legal Aid? These are on the Legal Aid YouTube channel and are in several languages.
Great, and there'll be links to all those website pages in an email that you'll get after the webinar.
So when is a grant of legal aid needed? You'll see on the screen, you can see a table of the services that are provided by legal aid. The top 4 services of legal information, Community legal education, legal advice, and minor assistance are all free and can be accessed by the general community. Legal advice is generally a 20-minute face-to-face session with a lawyer, and we encourage people to get advice before they apply for a grant of legal aid. Minor assistance depends on the circumstances, but it will be assistance to support a client, something like writing a letter. Extended legal assistance is taking carriage of a matter or multiple matters in an ongoing representative capacity, but because of the nature of the matter, it doesn't proceed to a court or tribunal. Applicants for an ELA service must satisfy a simplified means test and a merit test. And then the representation services are provided either in-house or by a private solicitor who is on a panel and is paid for by legal aid. This is ongoing representation in a court or tribunal, and clients must satisfy eligibility criteria, such as means or merit tests. Examples of where representation will be provided will be if somebody pleads not guilty to a criminal offence, if there's a family law parenting matter, or perhaps a civil law matter where a bank is thinking of taking somebody's home. And there are also grants available for duty representation.
Right, so basically in answering the question, when is a grant of legal aid needed, it's really just for legal representation.
Correct.
Great. So now we'll talk more about those 5 eligibility tests. So thanks, Adine.
Okay, so good morning, everyone. So when you come to legal aid, or one of your clients comes to legal aid looking for a grant of aid, we have what we call 5 eligibility tests. So these are tests that a person must go through to see whether they're going to get a grant of legal aid. The first test is called the jurisdiction test. And this really just means we look at whether your matter is a civil matter, a family matter, or a criminal matter. And then we look at the particular policies as to whether you're eligible for that matter. We then look at the means test. The means test is a core eligibility test, and we will be talking about that in a little bit more detail. When we look at means as well, we also look at whether you have to pay a contribution. So that's sort of decided at the time that we look at your means. The merit test, then we look at whether your case has reasonable prospects of success, and we will talk about that in a little detail as well. We also have an availability of funds test. We will talk a bit later about that test, and that's a sort of higher level test, not applied to each applicant as they apply for aid, but rather it's a decision the board will make at a higher policy level about whether we have funds to continue to provide representation in particular types of matters. And we also have a fairly new eligibility test called the Unpaid contributions test. And that's whether your client may have been here before and they were asked to pay a contribution and they didn't pay that contribution. That will remain as a debt to that client. So when they apply for legal aid again, that debt will come up and we will ask them either to pay it or, if there's reasons why they can't pay it, we will take that into account as well.
I guess the means test is just focused because that's the main one we're focusing on today.
Today, yes, yeah. So people often ask, why do we have eligibility tests? Well, at Legal Aid here, we're required to provide legal services to people who are socially and economically disadvantaged. So the tests are published, all our eligibility tests are published. It means that we can manage the limited funding that we receive from the government. It also means that we're accountable to the public, so everybody can see what legal aid is available for, and that provides fairness and consistency. So each person, when they apply for legal aid, will be treated in the same way, and as long as they satisfy those eligibility tests, they will be granted legal aid. So, briefly, the jurisdiction test, I spoke about that just a few minutes ago. So is legal aid available? What type of matter? There's examples that we don't do legal aid, and that would be for medical negligence cases, commercial transaction. We also don't grant legal aid for neighbourhood disputes or for applicants in apprehended personal violence orders. Anna mentioned two types of matters there earlier. One is a local court criminal law matter, and the other was family law matters. So in the jurisdiction test, we also ask you questions about whether, say, for example, it's a parenting matter. We will only grant aid if we are happy that there's a substantial issue in dispute. This really just means that we won't fund a matter if the dispute is simply about where your child has been picked up. So it's, you know, KFC rather than McDonald's. So they're the sort of things we will look at as well in that jurisdiction test. So the means test, as Natalie said, this is our core eligibility test, and it's what we'll be talking about a little bit more in detail today. So here we have you.
Okay. So we're going to talk about John and Paula in a minute, but first, just to kind of give you, I suppose, have a guess. So John and Paula's income is $115,000 as a family. Do you think that they would satisfy the income test to be eligible for a grant? Yes, no, or not sure? We've got people answering. It's a bit of a spread. I'll just give you another second. People changing their minds, maybe. Okay, I'll close that poll now and share those results. Thanks, everyone. So, aiding, very interesting. We've got 5% of people say yes, they will be eligible, 32% say no, and 63% are not sure, which is pretty fair enough.
Yes, that's...
Okay. So, do you want to explain John and Paula's situation?
So what I'll explain is generally what we look at when we look at income. So with an income test, what we're actually doing is we're looking at, we've built into our means test sort of basic sort of household expenses. So your rent or your mortgage is taken into account. So that's your housing costs, your dependent allowances. So any child you have, we will allow $120 a week for that child. Any maintenance allowance that you have to pay, so that's $120 per maximum per child. We also, you have a financially associated person, and we allow for $200 for that, and that would be your partner. So if Paula was applying for aid, John would be her partner, and they'd be able to deduct that $200. We also allow for childcare costs, and that's up to a maximum of $325. So what we then do is to come up with your net assessable income, which decides whether you're eligible. And at Legal Aid, that's $400 a week. And what we do to get to that is we take away all these expenses that you have. So you tell us what your post-tax income is. We take away all these expenses, and then whatever you're left with, and if that's 400 or less, that's your net assessable income. And if it's 400 or less, you're then eligible for Legal Aid.
So are you going to reveal if John and Paula are eligible?
Sure, we'll just cover the assets first.
Sure.
So in terms of what assets are allowed, again, you'll see this table, which is actually available in the policies and brief document that you've been provided with. So in terms of how we assess assets, it's the gross assessable assets, and we account for that allows for cost of living. So we allow for a set amount for land or shares, and also for holding things such as savings in a bank account or owning a motor vehicle.
Aideen, sorry, we've just got one question about the incomes, about the NDIS amount being excluded.
It's excluded, yes. We don't take into account the NDIS amount that people are getting because we're satisfied that that amount has been secured for those medical needs of that person.
Yeah. Thank you. I think that answers the question. Thanks. Sorry, Anna.
So in terms of, if we look at John and Paula's case study a bit more closely, we can see that John and Paula are married with 3 young children. John works full-time as a teacher, earning $91,000 per year, which is $1,299 per week after tax. Paula works 3 days a week in aged care, and she earns $24,000 per year, which is $434 per week after tax. They also receive a small amount of family tax benefit Part A. John and Paula rent in Lidcombe, paying $500 per week for a 3-bedroom house. The other main expense is childcare. They have one child who's in childcare 3 days a week, and the older 2 are in after-school care. So their total net childcare costs are $328 per week. With a combined income of $115,000, John and Paula satisfy the income test. So we'll go through to the next slide just to break that down for you in terms of how they satisfy the income test. You can see there that if we add John's income per week with Paula's income per week, we end up with $1,733. From that, you need to take the deductions. So we know that although they claim and they have said that their actual expense for rent is $500 a week, the deductions only allow for $455 to be deducted for rent. So we include that. Again, although their daycare costs are $328 a week, the deductions only allow for $325. They will get 3 lots of $120 deducted, 1 for each child, and then also $200 for the financially associated person. So that's deductions of $1,340 per week. So their income is actually $393 a week, which is under the allowable $400. In terms of how their assets meet the test, we can see from the facts that they don't own their own home, that they are renting a property, so we don't need to worry about equity in the home. They do have a Toyota Camry, which is valued at $18,000, which is under the allowable $20,000. And they have savings of $4,000 in their bank account, which is under the allowable $4,200. So they are also in on the assets test.
So very lucky for this scenario that
Yes.
they do fit in, but just illustrates that. So in answer to that poll question.
Correct. It's really a matter of stepping through and taking away the allowable deductions before you can really assess whether somebody will be eligible under the means test.
Yeah, but I think, Aidan, you said a lot of people are surprised to hear that.
Yes, yeah, we do quite a few talks around New South Wales, and people are always surprised because I think most people think legal aid is only available to people who are on Centrelink. So we're hoping that this scenario of John and Paula has sort of highlighted that people in, medium income households may be eligible for legal aid. So it's always important to put the application in.
Right, thank you.
So we also have an online means test indicator. Now, it is only an indicator, but it's often quite handy and your clients can use it. You can help them use it. It's available on our website. You can feed in all the information of your client and it'll give you an indication as to whether your client would meet our means test. But in saying that, always make an application because there are what we call discretions, which means in the grants division, people can decide that your circumstances are such that we can still grant you aid, even if your income is slightly outside the means test. You may have to pay a larger contribution, but that won't, but that'll also be something that we can look at. So it's always important, even if it looks like you're not eligible, to put an application in.
Oh, okay. I'm just going to do a quick poll before we move on, just to, I guess, check that everyone was listening. What is the current income amount that you can earn after deductions to be eligible for legal aid? So you've got on your screen there $400 per week, $100 per week, $115,000 per year, or you must be on Centrelink. Okay, thanks everyone. I'll just close that there. And share that with you. So Aidan, we've got 86% of people said the $400 per week, and we've got a couple of people who said $100 per week, or you must be on Centrelink. And I know some people have joined us late, so that might be why, but do you want to explain what the answer is to that?
Yeah, so the answer is $400 per week. Yes, that's the correct answer. So 86% of people got that right.
But we do hear a myth, I suppose, that people think you have to be on Centrelink to be eligible.
That's a very, very strong myth. Yeah.
Thank you. I'll close that. So, yeah, I guess contributions is another area that is a bit confusing, and that we just heard that John and Paula would have to pay a contribution. So what does a contribution mean?
So a contribution, at the time you apply for legal aid, we have the means test, and the means test then, depending on what your what we call the net assessable income, which is the 400 limit, depends on what that is, determines whether you have to pay a contribution. So generally speaking, if you're on Centrelink, it's not always the case, but if you're on Centrelink, your contribution would generally be $75. And that's at the very beginning of your matter. You can see that John and Paula have to would be up for a contribution of $1,150. So even though they're eligible on their income, so they're below the 400, they still need to pay that contribution. So they're what we call initial contributions, and they're calculated using our means test. As I said before, there's always discretions. So if there's a situation where, you know, your contribution was calculated at 1,150, and that might be based on your income, there may be occasions where, you know, that contribution could be reduced if there's really exceptional circumstances.
Great. And we've got a question as well about whether the contributions can be put on a payment plan or paid in installments, I suppose.
Yes, we've got lots of different methods of paying it. So even with the $75, we can use CenterPay. We can also you can pay it over a 6-week period. So yes, that's a very good question. Yes, we can. There's plenty of payment methods available. The other time we look at contributions is at the end of a matter. So some people, when they apply when they have legal proceedings, they may get compensation at the very end of the matter. So what we will do is we will calculate the contribution at the very end and decide how much that person will need to contribute. Generally, if it's a large compensation, we will ask for the total costs of the matter that it cost us to run. I do want to say as well, though, if you're coming to legal aid, the cost of running matters are quite significantly cheaper than if you were paying the full private amount. So that's one thing to bear in mind when you're talking about the total costs of proceedings, that you know, our costs are far lower than the costs of a private lawyer.
Hi. Sorry, Bridget. So moving on now, away from the means test to those other tests. Thanks, Bridget.
Hi guys, I'll just be discussing the merit tests. So at Legal Aid, we have 2 merit tests. We have Merit Test A, which refers to state matters, and we have Merit Test B, which refers to Commonwealth matters. So I'll just discuss Merit Test A. So basically, in deciding whether it is reasonable, Legal Aid New South Wales will take into account, amongst other issues, the nature and extent of any benefit that the applicant might expect to gain by receiving legal aid, or any disadvantage or harm to the applicant that might result from being refused legal aid, and whether the applicant has reasonable prospects of success. So I'll just give some examples in relation to a benefit. Basically, where you have a husband and wife who might be applying for legal aid, and one of the parties is simply supporting the other applicant. So they might say, look, I'm just supporting my wife's application. So we wouldn't consider that application has merit under the benefit detriment limb, because the client could simply just provide anything they want to provide to the other party's solicitors. So I'll give a good example of this is where, for example, let's say the mother has initiated Section 90 proceedings to get the children restored to both their care, and then she's got a legal aid application already granted. Her Section 90 application is already initiated, and then we have the father who says, well, I'm applying for my own separate grant of legal aid, but all I'm doing is I'm supporting the mother's application. So that kind of is an example of the benefit detriment limb, which we wouldn't consider that satisfies that. In terms of disadvantage or harm to the applicant, so basically there are some situations where a client necessarily, the orders they're seeking, we might not consider, do have the best prospects of success, but if they weren't represented legally, the disadvantage and harm to them would be detrimental. So there are some circumstances where we would consider that someone does need legal representation, whether it's a very complex matter, there is a lot of issues, and the client simply couldn't be able to represent themselves. So then we would consider that they would be at a significant disadvantage. In relation to reasonable prospects of success, that again goes back to really what do they want, and what they're seeking, is it reasonable in the circumstances? Is there an actual chance that they're going to get the orders they are seeking in a litigation environment? So that's kind of, I guess, a quick summary in relation to the state merit test. I'll just go to the Commonwealth. Basically, it has 3 limbs. So again, it's got the reasonable prospects of success test. Another example is in a Commonwealth matter, if a client is seeking live with orders and they haven't been the primary carer for the child's entire life, they might have some drug issues, there might be domestic violence, and really we might consider, look, they don't really have a chance of getting these live with orders. So that therefore the orders they're seeking do not have reasonable prospects of success. So that's kind of under that. In terms of the prudent self-funding litigant test, so the prudent self-funding litigant test requires the Commission to be satisfied that a prudent self-funding litigant would risk his or her funds in proceedings for which legal aid is sought. So would a private paying client risk their own funds to litigate this matter? Then the third limb is the appropriate spending of limited public funds test. So basically, in assessing an application, to consider the overall benefit to the applicant, or in some circumstances the community, of spending limited legal aid funds on the proposed legal action. So an example of this is, I think Aideen mentioned the substantial issues in dispute. So for example, if we're getting an application where they're saying, look, I want to pick up the children at KFC, not McDonald's, then we would say, well, basically, that's not an appropriate use of funds because it's not a substantial issue in dispute, and we wouldn't consider, therefore, that has merit under the third limb. So that's kind of, a quick summary on the merit test. And basically, the people who, I guess, in terms of the grants department, it's the solicitors who assess merit on all legal aid applications. So we will assess, basically if a client meets the merit test in the grants department.
And Bridget, it's the solicitors who are based in the grants department. It's not the person's own solicitor who makes that decision.
Yeah, no. So it's basically we get all the applications in, and then the grant solicitors themselves will have a look at the application, and then we will determine it.
And that second test you were talking about, the Commonwealth test, that's basically for family law matters.
Yes, that's for family law matters.
So moving on, if people have questions about the merits test or means test, I guess, please ask those and we can clarify things and talk more in the Q&A section at the end. But now we'll move on to one of those other, remember there are 5 eligibility tests, so we'll move on to, what are we up to? The 4th?
Number 4.
Number 4 now. Thanks, Bridget.
So just in terms of availability of funds, I think Aideen touched on this earlier as well. So basically, these decisions are made at a policy level by the board, and it's not an issue for individual applicants. So basically, if funding is constrained, the board may decide funding is not available for a certain matter for a certain amount of time, but individual applicants do not need to worry about this at all. And so with unpaid contributions, so basically this means that an applicant owes a debt to legal aid, and legal aid will be refused unless the applicant pays the debt owed within a specified time frame, or legal aid is satisfied that there are exceptional circumstances, or it is an exempted matter, for example, a non-means tested matter like minor assistance or children in the children's court or some veteran matters. So an example of this is where a client is applying for aid in family law and they have a bad debt on a previous criminal file that hasn't been paid. So we would not grant the new family law application until the client either pays the debt from the previous file or enters into a payment arrangement to pay that debt. So there are some exemptions. A good example of an exemption is where a client is in custody at the time of the legal aid application. So basically where they're in custody, we would consider that an exceptional circumstance and they wouldn't be able to pay the contribution.
So I guess and unpaid contributions is a good thing for community workers to be aware of, because they might have clients who've come back to Legal Aid a few times and maybe refused, and just to prompt their memory, that might be why. Do you have any unpaid debts to Legal Aid?
Absolutely.
Yeah. Okay, and I'll let you talk through Louise's situation.
So we have a case study of Louise, just as an example, sort of how to step through applying the 5 eligibility tests we've just been through. So Louise is a 68-year-old grandmother who speaks limited English. She cares for a 14-year-old granddaughter, Chloe. About a year ago, Louise's daughter, Vicky, asked her to sign a document because she wanted money to start a fashion business. Vicky said, "Don't worry, it's just the papers from the bank for a loan and I'll pay you back every cent." Vicky's business unfortunately failed, and the bank has now told Louise that they are going to sell her home. Louise has told the bank that she didn't know that she would lose her house, as her daughter told her the loan was for $50,000. She didn't read what she was signing, and she has a limited understanding of English. Louise receives the age pension at the maximum rate, plus maximum family tax benefit A. She owns her home in Penrith, valued at $500,000, and a car worth $15,000. Louise has $2,500 in cash, but no other assets. So the question is Louise eligible for a grant of legal aid? So in order to step it through, in terms of the jurisdiction test, Louise would meet that. These would be civil matters, either for loss of a dwelling or a consumer protection matter. In terms of the means test, she would be eligible for legal aid based on her income because she receives the maximum Centrelink payment, noting there that the family tax benefit, we do not count that. And her assets are also within the allowable limit. She's got her car's worth less than the $20,000 that we allow, and her home is worth less than the $521,000 in equity that we allow. So she satisfies the means test. In terms of merit test, that would require looking at the real detail of her case study. However, we can see that there are a lot of facts there around the fact that she has limited English and some issues around the information she was provided with on what she was told and her understanding of the loan. And it doesn't appear from the facts as though Louise owes a debt to legal aid. So it seems that she would be eligible for a grant in this particular matter.
Great, thanks, Sarah.
No worries.
So Bridget, just to summarise, I guess, the steps for now applying for legal aid, do you want to talk through those?
Yeah, so basically it's always the best to first talk to a lawyer. A lot of lawyers do offer that first free initial consultation where a client can discuss the matter with the lawyer. A lawyer can also explain eligibility and submit the form on behalf of the client. So it's the best chance of successfully applying for a grant of aid is if a lawyer completes the form on behalf of the client and submits it through the grants online system. So this system is a portable system, a portal for lawyers themselves to complete on client's behalf. If the client can't access face-to-face legal advice at our offices or outreach locations, they can always go into a legal aid office as well. There is also legal aid forms online, so you can download the paper application from the legal aid website. Basically, though, if a client can access lawyers, it is always good, though, that they submit the application on behalf, because usually it'll be more comprehensive for us to assess and we can move it through quicker. After submitting an application, it might take several weeks to hear back from the grants department unless it's an urgent matter. If it is an urgent matter, it's always good to give grants a call and ask us to expedite it, because if it really is urgent, for example, the client needs to be in court within 2 weeks, or it's an urgent recovery order, we can always expedite the application for a solicitor to have a look at.
Thanks, Bridget. And just to clarify, there's grants online, which is something lawyers fill out themselves, but there's also now back up an application form online for people to complete themselves, perhaps with assistance from community workers.
Correct.
Yep.
Or a paper form that they can complete with assistance.
So there's a few options, and those links will be in the email that you get after the webinar as well. Okay. So Bridget, do you want to talk about what's the best way community workers can help with grant applications?
So community workers can really assist clients with filling in applications, and it's really something as simple as making sure that clients are filling in the financial details correctly. So making sure, look, these are your details, not your partner's details, because the partner's details would go in the financially associated person section. So just making sure that the client says, look, are you on a maximum benefit? Sometimes the client won't know. So then simply saying, look, do you have access to your Centrelink income statement? Or you are on a maximum benefit. Just filling in those financial details really correctly will assist us in determining whether the client is eligible under the means test. Also something as simple as putting in their child's date of birth. Putting in this matter relates to this child, this is their date of birth, so we can see how old the child is. Also asking them, look, what is it that you want? What are you seeking? Are you seeking time with the child? Are you seeking to change the residence of the child? Do you want contact? So basically, and then asking them, why do you want that? Because there's a section in the application which client can say, look, this is what my matter is about. So it's simply, community workers saying, okay, sitting down with them and going, let's go through this. What is the matter about, and what do you want, and why do you want it?
So that's for a family law matter, and for like Louise's situation where the bank might be taking her home, she'd need to explain the steps about what happened and the chronology, I guess.
Yes.
And the other thing, Bridget, is the documents to attach right up front.
Yes, in terms of documents, I can't stress how important documents are with legal aid applications, because when we get the applications, we need to assess it on basically the documents attached. So in terms of financial, it's very important that the client attaches a copy of their Centrelink income statement, and these should be an actual copy, not photos, because sometimes we do receive photos that we can't read, or that doesn't actually show us that client is on the maximum benefit. Also, 3 months of recent bank statements from all accounts held by clients. So sometimes clients, again, will not understand what this means. It's very important that it is recent, because if you provide us statements from a year ago, we can't really assess that. Also, if you're employed, we require 3 recent pay slips, which show obviously what you earn. And if you are self-employed, we usually request a copy of your last tax return and financial statements and profit and loss statements. So it's very important that if you're assisting a client with the application, just ask them for these documents. They might not have it on hand, but if they do, they can always send them through, and you can even email them to us on behalf of the client. Also, court documents, especially in family law matters, they're very important. So, if it's in a Commonwealth matter, a copy of any orders that have been made, a copy of the initiating application affidavit, if that's available. And I'll just mention, because community workers might come across a lot of clients who want to apply for legal aid to get their children restored to them. And this is would be called basically under the CARE Section 90 application variation matters. So if you are assisting a client who does want one of these, it's very beneficial to say, do you have a copy of the final orders that were made? Do you have a copy of the current care plan? Do you have a copy of, details of the contact you've had, which is basically the Section 82 report, and any letters or certificates that show that they've addressed the significant change of circumstances since final orders were made. So something as simple as that would greatly assist these clients in applying for aid in those matters.
And there's quite a lot of running around to do, I guess, to get the bank statements and the payslip, like for anyone, I guess. So the clients might need a bit of assistance about how to do that.
Yeah, definitely.
Thanks, Bridget. I think that was really helpful. So now we'll talk about, I guess, what to do if somebody is not back or refused a grant of legal aid.
So you're supporting someone who has a matter in court and they've applied for legal aid. They come to you and they have a letter which tells them, just like this, that legal aid has been refused. It's really important that you tell them, you can do something about this. Firstly, you can ask the grants department to redetermine the application. Sometimes what can happen is you might have not provided the correct financial information. I often I go to the Legal Aid Review Committee, which I'll speak about shortly, and often what I see is people haven't, the grants division, as Bridget was talking, have asked you to provide, say, some bank statements and they haven't been provided. So sometimes refusal can be often just on that type of basis, but generally, so refusals are generally that your client has not satisfied the means test, the merit test. They may have that unpaid contribution from a previous matter, and that will be redetermined and aid granted if the contribution is paid within that specific time frame, or we decide that there are exceptional circumstances. There may also be that the client doesn't meet other policy requirements. So Anna spoke about local court criminal matters where your client may have entered a not guilty plea, which means they'll go to hearing at the local court. In these matters, you need to pass the means test, but also what we have now is a requirement that there is a real risk of jail. So often what will happen is an assessment will have been made in the Grants Division that there is no real risk that your client is going to jail, and that's why legal aid has been refused. But as I said, you can go back to the Grants Division, ask for the matter to be redetermined, or you can appeal to the Legal Aid Review Committee. So the Legal Aid Review Committee is an independent committee. They are appointed by the New South Wales Board. One of the members of the committee is appointed a combination between the Bar Association and the Law Society. One is a community member that's appointed by the Legal Aid New South Wales, and the chair, normally the chair is nominated by the Attorney General, and they then get appointed by our board. The time limit for appealing a matter is 28 days. There are exceptions though, so even if it's outside that 28 days, it's actually quite important to still submit your application. There are some decisions that can't be appealed. So for example, if your client is in the local court and they haven't satisfied the means test, that's not something that you can appeal against. Sometimes as well, legal aid decides that who's going to represent your client in a matter. So for example, in criminal law matters, generally that we like to represent most of the people in-house. So you can't appeal against that decision. So if legal aid decides that your lawyer is going to be from our Penrith office, for example, then you can't appeal to LARC against that decision. Also, there is, throughout the life of a grant, we will make decisions about how we're going to fund that grant, and those funding decisions can't be appealed to the Legal Aid Review Committee either. At LARC meetings, you'll be asked to provide all your relevant information. So it might be that you're giving updated means because you've been refused on means. The Legal Aid Review Committee will look at all that information. They'll have a discussion about your matter, and then they'll make a decision. They are, as I say, they're independent, and they have the same sort of delegations as the original decision maker that was in Grants Division.
Great. So that's the actual committee doing their work and eating sushi, looks like it.
That's right. So where to go for more information, I think.
Yeah, so on the screen now you can see there's some little animated videos called Can I Get Legal Aid, which are a really cute little summary of, I guess, what we've been talking about today, and they're in all those languages that you can see on the screen there. So they're on the Legal Aid YouTube channel, and there'll be a link to that in the email as well. So they're a good thing to check out and show to your clients as well.
So on the Get Legal Help tab of the Legal Aid website, we have links through to some resources, including an A to Z guide to policies. This is actually in the process of being updated at the moment. One of the other things that you can also find on our website is the policies in brief document, which has been attached to the material you're provided with today. And there's also the means test indicator, which we showed you earlier, which can also easily be located from our website.
So some final takeaway messages about grants of legal aid, Bridget, before we answer some questions that have started coming through.
Yeah, so basically, it's always important to see a lawyer first for free legal advice, and it's best if the lawyer submits the grant application. So even if people think they might need representation, it's still a good idea to see a lawyer first rather than just fill out an application form. And people can get free legal advice and minor assistance without a grant of legal aid. Also, if someone doesn't have a lawyer helping them, they should get some help to fill out the application form. Community workers can help, for example, to help people to explain what they want in their case. As we were saying before, example, I want to be able to spend time with the child or live with the children. Means test is income and assets minus deductions, so you can use the online indicator. Legal aid is not free, there are contributions, and a refusal of legal aid can be redecided or appealed to the Legal Aid Review Committee.
Great, thanks, Richard. So that brings us to the end of our webinar presentation, but we've got some questions coming through already, so I might read those out and we can all have a bit of a discussion and chat about those. So thanks everyone, and remember there's those couple of handouts attached to the webinar that you have in front of you, and you'll also get some links in an email in about an hour. Okay, so a question coming back to that means test, and I know Anna you mentioned with the Louise case study that 521,000 is in equity is allowed if you have a mortgage. Can you just explain a bit more about how a mortgage works for the means test? Nadine?
Yeah. So when you apply for legal aid and you tell us, we'll have a little, in the form we have sort of a space for this, we'll ask you how much your house is worth and how much you owe in mortgage. So for example, Sydney prices these days are quite extraordinary, but we'll just pick, say, Parramatta, where I think the average price or house now is around, I think, 1.1 million. And say you have a house in Parramatta and your mortgage is 600,000. So you still have 600,000 to pay back to the bank. Well, then we'll just take that away from the what's the value of the property. So if the property is valued at 1.1, you'll have 500,000 in equity, what we call equity. So it's the equity that we're looking at when we're deciding, so that's the equity we're not taking into account. So you're allowed to have 521,000 in equity before we'll require you to pay contributions. So what happens once you get above that 521 in equity, say, for example, you disclose that, in fact, your equity was 530,000, so you would have 9,000 over in assets. We then have a special calculator, and that's all part of the means test, to calculate the amount of your contribution. And once you're in assets, the contribution amount goes up quite steeply. So you would probably be looking at a contribution amount there of $8,500. So that's how it works.
I should mention as well that where a client is ineligible on means, solicitors in the grants department only have a certain discretion to reduce that contribution. So it may be the case that they will get a refusal letter on means assets if they did have an $8,000 contribution. So if there is a letter like that, it's just that if a client is ineligible and it's over $3,000, solicitors who are not senior solicitors in the grants do not have the discretion to reduce that contribution without the permission of a senior solicitor.
And I suppose to sort of explain that even a little bit more broadly is how you become ineligible under the means test is so we talked about the initial contributions. So when we calculate your net assessable income and your net assessable assets, and once they're over the allowable amounts, we start imposing a contribution. So when you become ineligible for legal aid, when the contribution amount we've asked you to pay is greater than the cost of proceedings. So for example, your contribution in your family law matter is $8,000, whereas legal aid may only be spending $6,000 on that matter. So we would say, well, you've got $8,000 in a contribution, it's only going to cost us $6,000, so you're not eligible for legal aid. You're going to need to use your own money to pay for that for your family law matter.
Thanks, Nadine. Hopefully that answers that question. Okay. So we've got some questions around people who are not Australian residents. Are they still eligible? Children, I think this is for a family law matter, if children are born in Australia but the parents are not Australian citizens, are they still eligible for legal aid? So yeah, good question. I don't think we covered that.
Yeah. So yes, there are circumstances where, you know, if they're not Australian citizens, that they are still eligible for legal aid. They still have to obviously satisfy the means test and the merit test. So we would still request a copy of all those financial documents, whether it's from an overseas bank account. We would look at those. But yes, actually, if you are not an Australian citizen, you can still get legal aid. You just need to satisfy the same requirements that an Australian citizen would need to satisfy.
And I know at Legal Aid in the civil law section we give advice and represent people in immigration matters. So I assume there's a lot of situations where people are not Australian citizens.
Oh, yes, yeah. And a lot of our drug importation matters would be overseas people. So the only requirement for legal aid currently, because I know it is different in other legal aid commissions, is that the proceedings are being held in New South Wales. So that's actually the forum test that we use. So if the proceedings are in New South Wales, then Legal Aid New South Wales, Legal Aid is available from Legal Aid New South Wales.
Great, thank you. Sorry, a question about the unpaid contributions. Can you explain more about when those might be waived? Like if somebody has been in prison for 10 years, say, I guess, when would you waive the unpaid contributions? Would you?
So I guess it goes back to that original example where a client is in custody and they're not earning any income. We would consider that an exception, and we would not require the client to pay that contribution because they don't have the ability to pay that contribution. Also, there are some circumstances, for example, where a woman is suffering domestic violence and she's in a refuge, and we would consider, look, she's in a refuge, she has no funds, and we would waive that contribution because she doesn't have the ability to pay. So where a client is in a detrimental financial circumstances, we can waive the contribution. What happens usually in those situations is either the client or the solicitor who submitted the application, or even a community worker who submitted the application on behalf of the client, they can request discretion. So they can say, look, client can't afford to pay any contribution and this is why. So we do consider things like being in custody and overall financial circumstances. And so those are kind of the situations where we would consider that, you know, there is the possibility of waiving those contributions. We can also reduce a contribution. So it might be the case that, you know, it's a contribution is $1,500 based on the client's income or assets. And they might say, look, we note that if there's a $1,500 contribution, however, you know, client can't afford to pay this because of these reasons. So we can also reduce the contribution down to, for example, $75 if we think that the situation warrants that.
Thank you. I can't see any more questions coming through at the moment, but we've got a few minutes, so we might let people have a think. And in the meantime, I might put you on the spot and just say that we're doing another webinar this time next week on some grants for people who experienced domestic and family violence. So do you want to give a brief kind of intro or blurb about that session and what we'll be talking about next week? Thanks, Aideen.
Okay. Last year we did quite a large review of our eligibility policies, and we were particularly looking at ensuring people who are experienced domestic and family violence were able to access legal aid. We found probably one of the main areas was in family law. So we will be talking to you about the availability of legal aid in family law matters, and not only children's matters, but property matters. Property matters are, you know, generally quite difficult to get legal aid for, but we have now sort of really redrafted those policies to make it much easier for people who are experiencing family or domestic violence to access grants of legal aid. And we're also looking at a few sort of issues in criminal matters as well. So that's what we'll be covering next week, our new suite of policies to assist people with family and domestic violence.
Thanks, Aideen. So if you haven't registered for next week, you can hop onto the Legal Aid New South Wales website under workshops and webinars and find in the calendar for the 19th of March. Yes. Okay. Unless there are any last minute questions, I think we will say goodbye for now. As I mentioned, there will be an email that comes out in about an hour and also a survey. Please complete the survey. That would be great. And this webinar, you'll be able to watch a recording of this webinar and pass that on to your friends and colleagues after this. But thanks, Anna, Aideen and Bridget, for your time and expertise today. And we will see you next week.
Thanks,
Thank
Emily.
you.